Thank you, and welcome back, everybody. Welcome to Talent and Rights, What You Don't Know Can Hurt You, with Amy Cornelius-King of Extreme Reach. If you are looking for simplifying post-production workflow with Showtime Networks, head back over to the Agenda tab and click Track 1, but this is where you want to be. So don't forget during the presentation to type your questions in the Q&A box at any point through the session, and I'll be watching those and be ready to do that with the Q&A at the end of the presentation. And without further ado, I would like to pass this now over to Amy Cornelius-King. Over to you, Amy.
Thank you so much, John. I really appreciate it. And I really appreciate the opportunity to be here and speak today. And thank you all so much for being here, both for coming to the Video Asset Symposium and for deciding to come to this session. My name is Amy Cornelius-King. For over 7 years, I was a talent manager at Extreme Reach, helping manage all kinds of clients, everyone from big advertisers to smaller boutique agencies with their talent and rights needs. And I've recently transitioned to move to our CAM team at Extreme Reach, which is our asset management system, where I'm using my talent and rights knowledge to enhance some of our offerings there. And the presentation today is called Talent and Rights, What You Don't Know Can Hurt You. And we'll discuss the ways that's possible. Most notably, it's in your wallet, which is something we all care about. So we're going to go ahead and get started. So talent and rights form the basis for where, when, and how you can use an asset. And what do we mean by talent and rights? Talent, when we say talent, we mean the people who appear in a commercial. Now, this could be the people you actually see on camera, but it can also include off-camera performers as well. So people like voiceovers, singers sometimes. So talent is anybody who appears either on camera or off camera in a commercial. And rights mean third-party licenses or agreements that are used within your asset. So things like music licenses, stock footage, other types of licenses, font licenses, things of that nature. And it's really important to have a handle on all of those things because those things dictate where, when, and how you can actually use an asset. And it's critical to know that because if you use an asset outside of compliance of one of those components, it could spell big legal trouble, breach of contract, and talent fines. So let's go ahead and take a look at what this looks like on an asset. If we take a look at this asset here, it has two rights associated with it: licensed music, stock footage, as well as talent. And it can be overwhelming to try and determine the exact ways in which you can use each one of these components. So I'm going to talk you through a simple flowchart to help you understand the things you need to know about each of your rights and your talent and how that feeds into compliance and whether or not an asset might be available for use. So if we take a look at the licensed music, the first question we need to ask ourselves is, are the rights within the desired term? Meaning this music license, does it cover us for our desired usage? So let's say, for example, that we want to use an asset on YouTube through September of 2021. We need to make sure that our music license covers us until at least that long. If the rights are not within the desired term, this right is not in compliance, and therefore the asset would not be available or clear for usage. Now, you can maybe go back and negotiate with your music license for the extended usage or exactly what you need. But if you're looking to take something to use quickly or just looking at the asset as is, what might be available for use, this one component being out of compliance would mean that the asset wouldn't be able to be used as is. However, if the rights are within the desired term, the next question to ask is, are the rights allowed on the desired platform? In this case, we want to use the asset on YouTube. So we want to make sure that there's language in that music license that covers us for internet usage, doesn't exclude any specific platforms that were covered there. Again, if the answer to this question is no, that's going to mean that this particular right is not in compliance and therefore we can't use the asset. However, if the answer is yes, if the rights are allowed on the desired platforms, the final question we need to ask is, are the rights allowed within the desired territories? So if we're putting this on YouTube, let's say we want to use it worldwide, we want to make sure that that music license doesn't have specifications in there that requires that the spot be geofenced for a particular location or only used in a certain location. Again, if the answer to this question is no, this particular right would not be in compliance and the asset would not be available for usage. However, if the answer is yes, then this right is in compliance And the next step is to check the other rights and talent associated with this asset. So by asking ourselves these three questions and going through this flow chart, we've covered off on the when, where, and how of this particular right, and that gives us information about how we can use this asset. So we've checked the licensed music. The next step is to check the stock footage. And this process is going to look exactly the same for the music license, so I'm going to move through it a little bit quickly. The first question we ask is, are the rights within the desired term? We want to make sure that the stock footage license covers us for as long as we need, just like we did with the music license. Again, if the answer is no, the right is not in compliance and the asset not clear for use. However, if it is, we need to make sure that the stock footage also covers us on the desired platforms as well. Again, if the answer is no, the right is not in compliance and the asset not clear for use. However, if it is allowed on the desired platforms, the final question to ask is it allowed in the desired territories? So we want to make sure this stock footage would cover us for that worldwide use as well. Again, if the answer is no, not in compliance, and the asset would not be clear for use. And if the asset is in compliance, then we still need to go check our other, and if the right is in compliance, then we still need to go check our other talent and rights that might be associated with this asset. So it's really important that we ask ourselves each of these questions to cover off on the where, when, and how. And I think it's really important to note that if the answer to any one of these questions is no, that means that the right is not in compliance, and therefore the asset would not be available for use. So we've checked the stock footage. Our final step is to check the talent on this. And this is where it can get a little bit more nuanced. So we've checked the stock footage, we've checked the music license. The next question we need to ask when addressing talent, which can be a little bit more nuanced, a little bit more complicated, is because talent can fall into one of two categories. They can be union or they can be non-union. And today, we're speaking specifically about SAG-AFTRA, which covers the United States and usage in North America, though there are other unions throughout the globe. So the first question you need to ask when dealing with talent is, are the talent union or are they non-union? If the talent are union, they would be covered under what's called the SAG-AFTRA Commercials Agreement. And that is a large umbrella that encompasses several other smaller contracts and agreements, which you see here on the screen now. So under the SAG-AFTRA Commercials Agreement, there are several other ways to contract your talent. There's the traditional, made for internet, made for new media, alternate compensation structure, social media waiver, low budget waiver, and then celebrity guarantees may also fall under this umbrella as well. And these smaller contracts will dictate some of the where, when, and how you can use an asset when it comes to talent. So for example, if you have an asset that you want to use on broadcast, but your talent are contracted on a made for internet agreement, that's not going to be possible unless you go back to your talent and renegotiate or recontract with them. Same thing for made for new media. If you have your talent on a made for new media contract and want to run it on cable or national network, that's not possible without recontracting with them. So it's important to know not only are your talent, whether your talent are union or non-union, but if they are union, what type of contract they fall under underneath that SAG-AFTRA umbrella. But before we get more into the union, I want to go ahead and look at what happens if your talent are non-union. So what if the answer to this initial question, are your talent union or non-union, is no? And if it's no, it's going to look exactly like the process we went through for the music license or the stock footage. And that's because non-union talent tend to be on contracts that are buyouts for a set period of time that cover certain types of usage in a certain territory. So the questions we ask ourselves for non-union talent are going to be exactly the same as they would for stock footage or the music license. So the first question we ask is, are the talent within the desired term? If we're wanting to use a spot on YouTube through September 2021, we need to make sure our non-union talent are contracted for at least that long. If the answer is no, the talent would not be in compliance and the asset wouldn't be clear for use. The next question to ask, just like with the music license and stock footage, is, are the rights allowed on the desired platforms? So if we want to run this on YouTube, we want to make sure we have those rights in the talent contracts and there's not specific language in there that excludes certain platforms or excludes certain types of usage that we may need. Again, if the answer is no, the talent wouldn't be in compliance and the asset not clear for use. And the final question to ask is, of course, are the rights allowed in the desired territories? So we want to make sure with those talent contracts that there is nothing in there that excludes certain areas, especially if we want to use this for worldwide use. There's no language in there that says it needs to be geofenced for a particular location. And again, if the answer is no, the talent wouldn't be in compliance and the asset wouldn't be clear for use. However, if the answer is yes, then the talent are in compliance. And because we've also checked the other rights on this asset, we now know that this particular asset is clear for usage. Something I do want to mention here while we are talking about non-union talent, because I think it's important. Most of the time, let's say you have 10 performers in a non-union spot, most of the time your contracts will be the same performer to performer, but I have seen cases where they can vary slightly. So it would be important just to take a look at your contracts and ensure that all of your talent are on a contract with the same terms. Otherwise, you would need to go through this process for each individual performer. Sometimes the terms, platforms, territories, usages can vary, especially if the cast categories are different between performers. So if you have a voiceover versus an on-camera, there may be some slight differentiation in the terms. It just depends on how your legal has written up the contracts, but it is something important to consider as you go through this process because you don't want to be surprised down the line with a breach of contract or talent fines. Okay, so now let's look at union talent. And these questions are going to be a little bit more different than the ones we've looked at previously. So if the answer to the question, are the talent union, is yes, the next question to ask ourselves, kind of like we discussed a little bit earlier, is does the type of contract allow for the desired usage? So under that SAG-AFTRA umbrella, you have these various contracts, the traditional, the made for internet, the made for new media, and those types of contracts can dictate some of that where, when, and how you can actually use an asset. So it's critical to look at not only are the talent union or non-union, but if they're union, what kind of contract are they on? Like I mentioned earlier, if you have an asset that you're wanting to run on broadcast, but you have your talent contracted on a made for internet contract, you're going to need to go back to your talent and renegotiate, and that asset wouldn't necessarily be clear for usage right off the bat. However, in this case, what we're looking to do is to take an asset and put it on YouTube, let's say through September 2021. So if our talent are on a made for internet contract, that would be allowed and it would be okay. So if the answer to that question, like I mentioned, is no, the talent wouldn't be in compliance, you would need to go back and renegotiate or pick a different asset to do this exercise with. However, if the answer to the contract question is yes, if you do have your talent on a contract that does cover your desired usage, the next question to ask is there a current reuse cycle that covers the desired usage? What does this mean? Well, with SAG-AFTRA, unlike with non-union agreements where you're kind of paying a set sum up front for a period of time for a certain type of usage for certain territories, with SAG-AFTRA, you're going to owe residuals to performers according to exactly when, where, and how a spot airs. So for example, if you have a spot running on cable, let's say broadcast on channels like ESPN, Comedy Central, Bravo, that is a certain type of payment that is due to performers, which is different than the payment you would owe, let's say, if you ran on national network during the Super Bowl. And that is different than, let's say, the payment you would make if you're putting an asset up on YouTube. And yes, you are going to owe residuals to performers, even if you're just putting a spot on YouTube, even if there's no paid media behind it, even if it's up just organically, you're still going to owe money to those performers. And that's something that's really important to understand. So you want to ask, is there a current reuse cycle that covers the desired usage? In this case, we're looking to put an asset on YouTube through September 2021. So we want to make sure or see if there is an internet cycle paid to these performers that would cover us for that type of usage. If the answer is yes, nice and easy, the talent are in compliance and you can go ahead and use that asset. And we've checked the other rights associated with this, so we know that this asset is clear for use. Now, if the answer to this question is no, it is not an automatic deal killer. The next question we would need to ask is the asset within the MPU? And if applicable, is there a current holding fee paid? What does all this mean? MPU stands for max period of use. And generally speaking, there are some exceptions. With SAG-AFTRA commercials, you have 21 months from the date it is recorded or filmed to use that asset. So in this case, we want to make sure that if there is not a current internet cycle paid that would cover us for this type of usage, we want to make sure we're within the MPU. And in this case, we want to make sure that the max period of use is not before September 2021. If it is before September 2021, this asset wouldn't be available for use in the way we want it, and we would need to go pick something different or go back and renegotiate with the talent. And then the next question to ask here, the other piece of this that's really important, is there a current holding fee paid? Holding fees are the most important payment you can make to union performers. They are due every 13 weeks on a regular schedule to performers for as long as you wish to continue to use the commercial. And they do two very important things. One, they maintain the performer's exclusivity to your product, meaning that if you hire the performer to do a commercial for your beer brand, they can't go off and do a commercial for a competitive beer brand. And the other important thing that holding fees do is they maintain your rights to continue to air the spot. So it's critical to make sure not only that the commercial is within the MPU, but that there is a current holding fee paid, because having a current holding fee allows you to continue to use it and to make that reuse payment cycle. There are some exceptions here and there for when you may not necessarily have to pay a holding fee. We won't get into all of that today because that's pretty in the weeds, but it is something that's pretty important to look for. So if the answer to this question is no, if the spot is not within the MPU, if there is not a current holding fee paid, that is a deal killer. That means that your talent are not in compliance and you can't use that asset. You could go back and renegotiate with the talent, but if you're just looking to pick something to use or use something as is, the talent wouldn't be in compliance. However, if the answer is yes, technically the talent are in compliance. Technically, you're allowed to use that asset, however, in the way that you would like, having gone through this flow chart. But just a word of caution, because with SAG-AFTRA, you owe residuals to talent according to exactly when, where, and how you use it. You're going to owe them some money. Great. So with this particular asset, we've kind of gone through the process of how important it is and how to actually check to see whether or not these rights and talent are in compliance. And that gives us important information about whether or not we can use an asset. So as I mentioned, I was a talent manager with Extreme Reach for many years, and now I'm working on our CAM team, which is our asset management system. So I've been thinking a lot about how asset management systems like CAMs and DAMs and MAMs can help manage talent and rights. So how can they help manage talent and rights? And I think there's a couple ways. So first of all, they can help summarize your talent and rights information. They can collate reports and information that are associated with an asset. They can give you access to CAS lists, and they can help track your rights that are associated with an asset. And I think when you have an asset management system, it's really critical to have all of this information at hand, because it helps you determine what assets might be available for usage. And we saw this a lot during the pandemic when production shut down. Many brands, many advertisers went back to past assets, went back to past spots to pull them to see what they could use with productions being shut down. So having that information at hand along with your assets is really critical. And what I'm going to do now is just pop out of the presentation here and just show you some examples of how this works within Extreme Reach's system. So if we take a look at this asset here, we have all of the technical information associated with the asset, but we also have a nice tab called the Talent Summary tab. And we have important dates here with the first film and record date. And another key date we have here is that important date I mentioned earlier, that max use date. This is a union spot, so that max use date is really important. And in this case, it is November of 2021. Scrolling down here, we also have the talent and rights calendar, which gives us a really nice at-a-glance look at what we've paid so far to the talent. We see that information in blue. And again, knowing what we paid to talent for the SAG-AFTRA spots, especially for union spots, is critical, because that gives us information about when, where, and how we can use it. And we also see two entries for music licenses, one that expires in December of 2020 and one that expires in January of 2022. And if I bop over here to my rights tab, I can see the two music licenses here right at the top. And I know that one covers the internet and it covers it worldwide. until January 2022. And the other one covers broadcast, again, worldwide until December of 2020. So I have that when, where, and how information with regards to my rights then as well. And if I come back to this talent summary page and scroll down here to the bottom, I also have all of my reports that are associated with this particular asset. So completion reports and session reports. And I can click on any one of these and open it up and have the completion report show, have that information at hand. I can attach information to this so I can have access to my talent contracts if I need that information, as well as have this report which shows everything about this asset gathered together in one place. And then if I come back here to my rights tab, I can also click and open information on any one of these rights and have really detailed information about my rights as well. According to when, where, and how it can be used, which we see reflected in the summary. And there's also spaces to attach it, to attach the actual license so you have that information at hand, contact information so you know who to go to should you need to renegotiate the license, things of that nature. So we have both information that is nice and in a summary format, and also we can take a deep dive to look at some of the deeper information that we might be interested in when looking at this asset. Just going to bop back to my presentation here. So it can be critical to track talent and rights information in a DAM or a CAM or a MAM system in your asset management system, so you have that information available and at hand, which can help inform your business decisions about what assets to use, what might be available for usage. But what are some of the consequences of not tracking your talent and rights information in a DAM? And I think there's a couple. One, complicated workflow. If you don't have that information at hand, maybe you've got to get on the phone or email 3 different people, 10 different people, however many different people, because there's so many entities now involved when it comes to making spots, when it comes to making assets, that if you don't have all of that information gathered in one place, it can mean a really complicated workflow when it comes to reusing assets. And you also have uncertainty in not knowing what spots are available for use. If you don't have that information there, you don't know whether or not you can use it. And those 2 things can lead to breach of contract, legal issues if you're airing something out of compliance, and ultimately talent fines, which hurt the bottom line. So again, just to reiterate how a DAM can help manage talent and rights, you can summarize your talent information, collate the necessary reports, everything you have associated with your asset, can give you access to cast lists so you know exactly who is in your spot, and it can help you track your rights that might be associated with an asset, which again, knowing all of that information, having it all at hand, we've discussed how to walk through the process of determining whether your rights or talent are in compliance and therefore an asset would be available to use. If you have that information available at hand in your asset management system, it's only going to serve you well. So that was a lot of information I just threw at you. We went through a lot. Thank you so much for your time. And I'm now happy to take some questions.
Excellent, Amy. You know, how many times we all have to realize to know your rights. Yes. All our content, you know, it seems ridiculous to say it, but that content, what can we do with it? But more importantly, what can you not do with some of the content? Excellent. There is a whole bunch of questions coming, Amy. Let's just start at the top. Number 1, is the ad bridge system available for commercial use, or is that an internal system specific to your company? Good question.
Yeah, it is available to, it's our internal system that we use for paying talent, tracking talent, but it is also an external system as well for our clients to utilize too. So we have a lot of clients that utilize the system to send us information about talent payments, to traffic spots, to manage their assets. So yes, it is available for clients as well.
Awesome, awesome. We have a question from Mary. Mary asks, what percentage of spots do you think are being produced union versus non-union? And are any of the non-union spots being produced 100% rights free in perpetuity? That's a double question. Wow.
Yeah, that's a tough one. in terms of the clients I've worked on, most of the clients I worked on tended to be union clients, but there are still lots of non-union houses out there who produce great non-union work. In terms of rights free in perpetuity, I don't see that too often. There may be a right or two on an asset that are bought out in perpetuity worldwide forever and ever and always. But I tend to see more that there are restrictions for terms or territories or specific usages.
Awesome. Good question. Very good question. Thank you, Mary. We have a question from Anonymous. Hello, Anonymous. Anonymous asks, Amy, if someone hasn't followed the rights information, how do you resolve that? Good question.
There's a couple ways to resolve it. I think if you realize that you've aired something out of compliance, the best thing to do is to take it down right away, wherever it is. If you're running it on broadcast, to pull it from air. If you've got it somewhere up online, yoink it down, get it out of there. And then you can go back to the rights holders who have rights on that spot or your talent and say, I'm really sorry, we just aired out of compliance. What can we do here? Or, you can also kind of wait and see if they come back at you too. It's a business decision you would have to make.
Got it. Yeah, you're getting some positive reviews of your flowchart. Well done.
Oh,
well done on that. Are there other ways to track talent and rights other than in a DAM system?
Yeah, for sure. There are many systems out there. Some people have proprietary systems that they use internally, either at their agency or advertiser, that they use to track talent and rights. Some people use Google Docs, Excel spreadsheets. There are many other ways than a DAM. I think the benefit of a DAM is that it pulls everything together and has it all in one place, rather than having all of these disparate systems where you have information kind of all over the place. But yeah, there are other ways other than a DAM. Got it.
Again, in the chat window, a lot of positive comments coming in. Well done for that. And just make sure when you're asking questions, put it into the Q&A box, but I'm watching that carefully. Interesting question. How do celebrity guarantees contracts work? How do you determine the rights on a celebrity agreement? Ooh, good one.
Interesting. That is a good one. And that is, celebrity agreements are interesting because most of the time they will fall under some unions. So a lot of the ones I've dealt with fall under SAG-AFTRA, but then they also kind of exist as a right as well. So you have the union rules, and then you may also have specific things within that celebrity agreement that dictate that when, where, and how. So, for example, like I mentioned with SAG assets, you usually have 21 months to use it. With a celebrity agreement, that term may only be 6 months or 1 year, and there may be stipulations in there about where you can't use it. Sometimes with celebrity agreements, in SAG-AFTRA, under SAG-AFTRA, we say there's something called industrial use, which is like you need to be there to see it. So like airings in the back of cabs, at windows that might be at a checkout, whatever. And sometimes celebrity agreements have like, you can't use this in the cinema. That's struck out. So it's really important to assess your celebrity agreements, both for SAG-AFTRA and then as a right as well.
That's very good to know. Thank you. Thank you. I think we have time for one more question. This is from Suzanne. Suzanne asks, seeing talent contracts are stored on AdBridge. Are they redacted to protect the talent's pay, etc., or is permission access to these documents controlled within the portal so only certain staff can see them? Does that make sense?
Yes, it does. So our platform is permission-based. So if you're sending us talent information to pay performers, that would be able to be accessed by our talent managers because we need to have that information in order to pay the talent. And then with AdBridge, on the client end, you can also log in to see information about what was submitted, what your talent information is, and that is all permission-based. So if you have certain people at your company that you don't want to have access to certain areas, we could make sure that happens. And if you need other people with full access, they would be able to have full access.
Excellent. Our time is up. Everyone, please join me in thanking Amy for this excellent presentation. I learned a whole bunch. Thank you so much.